right. State argument.
Thank you, Your Honor. Let me switch me over. Now, I have to kill you. These are the last words Christine Mac heard on August 8th, 2014 from the defendant, War Machine, aka Jonathan Copenhagen. They're the last words that she heard from a man she spent 15 months on and off again with. Those words were spoken about 2 hours after Ms. McInday watched the defendant pummel and beat her friend, Cory Thomas. Those words were spoken only a few minutes before this photo was taken. After she had endured nearly 2 hours of beating, hitting, and other forms of punishment. Those are the words she heard, and those are the words that when she had an opportunity caused her to leave the residence as she heard the defendant rummaging in the kitchen. Those are the words that were going through her mind as she ran to her neighbor's house, the next neighbor's house, and the next neighbor's house, until finally she was able to get assistance. The state has proven beyond a reasonable doubt that the defendant has committed the 34 counts charged in the information. What I'd like to do with you, as I know you were just instructed, I would like to explain the facts and how they relate to the instructions now. In every criminal case, the state must prove 2 things. First, that a crime was committed, and second, that the defendant was the one that committed that crime. Let's start with the second point. It was Mr. Copenhagen. It was the defendant who committed these crimes. There's been absolutely no evidence presented that would lead to any other conclusion that these crimes were committed by anyone else other than Mr. Copenhagen. This is not a whodunit case. This is not a question of who did what. The question is now, what crimes were actually committed? And that's where I want to focus most of my attention. To organize you a little bit, I'm going to do my very best to go through each charge one at a time in the order in which they appear in the information. It is not necessarily chronological, but to kind of give you some guidance, that is kind of what we will do. So, let me give you some background. Bring to your recollection some of the interactions of the defendant and Ms. McInday prior to this occurring, these crimes occurring. In about May of 2013, they meet at a hustler shoot. The defendant was asked to do the shoot, and he insisted that Ms. McInday do the shoot with him. They were successful in getting Ms. McInday to do the shoot also, and that's when they first met. They began to date a couple weeks after that. Ms. McInday described that it was a pleasant and happy time, just like most relationships start off. They would go to the movies, go on dinner dates, and I believe it was my recollection of the testimony that she even said that they went to the park. They did things that would be fun and exciting, things that people do when they're first dating. This relationship was a long-distance relationship, one where the defendant lived primarily in San Diego, one where Ms. McInday lived primarily in Las Vegas. They continued to visit each other often. There were even times when Mr. Copenhagen lived with Ms. McInday at her residence in Las Vegas. The relationship was on and off. Not long after they commenced their dating relationship, some of the abuse popped up. And that's where I will talk to you now. Count 1 is related to the Ferret cage incident. There was another incident. Count 4, a which I will refer to as the snake water incident. Counts 7 and 8 refer to the Boulevard Mall incident. Counts 9 through 12 are in relation to what we have termed the Houston incident. These are all crimes that you must deliberate upon in the back, and therefore I want to discuss them a little bit further with you. And we'll start with count 1. Count 1 is charged as battery constituting domestic violence strangulation. Battery is any unlawful and willful use of force against another. It constitutes a domestic violence relationship if the battery is committed against a spouse, a girlfriend, someone you live with, a former girlfriend, on a variety of levels. Ms. McInday and the defendant fit this description. This is a domestic relationship. And so any battery between the two of them constitutes domestic violence. Now, strangulation. Strangulation is the intentional impeding of the blood or breathing that causes a risk, not actual, but causes a risk of death or substantial bodily harm. So, let's talk about the facts then that would assist us in determining whether or not the defendant committed this crime. The defendant was upset that Ms. Christine McInday had given a ferret cage to Aaron McInday. You'll recall one of the more memorable experiences here in the courtroom. Ms. McInday initially liked Mr. Copenhagen. However, with time, she began to dislike him. In fact, on the stand, you'll recall, I wish I would have shot him. The defendant and her do not get along. This upset the defendant to the point where he grabbed Miss Christine McInday by her neck and by her neck carried her to the laundry room. Christy testified that she was scared. You might recall that this was one of the first times that she got emotional on the stand, bringing back that fear to her. Something that had happened 2 years ago, still causing her fear, concern, anxiety. She testified that she saw stars and that she could not breathe. This impeded her breathing. It affected the blood and also the oxygen that would get to the brain. This is battery constituting domestic violence strangulation, and the state has proven it beyond a reasonable doubt. Count 4 is the snake water incident. This is again a battery constituting domestic violence strangulation. And let me give you some background before we move too much further on. You'll recall that the defendant insisted that Ms. Christine McInday change the snake water, the water that the snakes would use. She apparently did not clean it in accordance to the defendant's standards or desires. This upset the defendant. Christy testified that the defendant made her drink the snake water. As if that was not punishment enough, he then goes on to strangle Ms. McInday. I won't go over the definition again because we just discussed it. But the defendant was upset. He was mad. And what happened here is this time the defendant picked Christy up by her neck, and again he carries her by her neck, this time to the bedroom. She saw stars and she could not breathe. This again is battery constituting domestic violence, strangulation. The Boulevard Mall incident. This would have been sometime in February or March of 2014, was Christy's testimony. You'll recall that Christy and the defendant went for some sushi. As they were finished with the sushi, Ms. McInday had chosen to wear some wigs and also some gold fangs that were made for her out and about the town. The defendant was upset after the sushi. He was mad that she was continually wearing these wigs. He did not like the wigs. He began to scream at her. And at some point, he ripped the wig off of her. The defendant was also mad by the fangs that she was wearing. You'll recall her testimony was that she had paid some man in California for these gold fangs. That was not pleasing to the defendant. After he rips off her wig, Christine Mac's testimony was that she removed the fangs from her mouth, knowing that she was going to be struck. She unlocked her seatbelt in preparation to exit the vehicle. As they got to a red light, she attempted to open the door and exit. But it was the defendant that grabbed her and prevented her from leaving the vehicle. He then smashes her head or face, more appropriately, into the dashboard. Christy also testified that she was bit on the bottom left portion of her chin. After driving her to a parking lot, he then said to her, "I've got to drive you to the desert and kill you, because this happened in public." So what crimes occurred during this incident? Count 7 is first-degree kidnapping resulting in substantial bodily harm. So what is first-degree kidnapping? This is a willful seizure, confinement, abduction, concealment, kidnap, or carrying away of any person by any means whatsoever with the intent to hold or detain, or who holds or detains the person for the purpose of killing or committing substantial bodily harm or sexual assault. In this particular point, we've only alleged killing and or inflicting substantial bodily harm. So that is what the state must prove, that it was willful, that there was some sort of seizure or confinement, and that it was done with a specific intent to either commit substantial bodily harm or to commit murder. Again, the effect of that, whether or not she suffered substantial bodily harm or whether she suffered death, is not important. It's the defendant's intent that is important. So, we need one more definition then as we discuss this. And what is substantial bodily harm? Substantial bodily harm is one of two different things. First, it can be injury that creates a substantial risk of death or impairment to any member or organ of the body. So anything that could cause death or anything that affects your organs or member of your body, or it can be prolonged physical pain. And prolonged physical pain has been defined for you in your instructions as something beyond the immediate effect of the injury. So you need not exact the killing or the substantial bodily harm. The law does not necessarily require that the person being kidnapped be moved. That's not an absolute necessary element. So let's talk. How do we know that the defendant willfully seized, confined, or abducted Ms. McInday? Well, she testified that she prepared to exit the vehicle, that she undid her seatbelt. She testified that at the red light, she attempted to exit the vehicle. The defendant prevented her from leaving it. That is a confinement. That is a seizure, not allowing her to leave the vehicle. Christy told you that she did not feel like she could leave. That was her testimony. Now, what was the intent? Well, we know what the intent was because as soon as he pulls her back into the car or prevents her from leaving more appropriately, he then smashes her face into the dashboard. That smashing caused a chip in her tooth. And you'll recall a photo, that the exhibits will all be back there with you. But there's a chip in the tooth. That is an impairment to a member or organ of the body. It required some sort of medical oral procedure to fix. He also told her that he had to take her to the desert and kill her. That proves the defendant's intent. That proves what his purpose was in preventing her from leaving the vehicle. You have it from the defendant's own words, and you have it from Ms. McInday. Count 8, also related to the Boulevard Mall incident, and this is in relation to the tooth that we just discussed. Battery resulting in substantial bodily harm constituting domestic violence. This is any willful use of force against another that results in substantial bodily harm. We've discussed this. She removed her fangs for the purpose, knowing that she was going to get hit. She knew she was getting hit, and she removed them. For that, she got her face smashed into the dashboard. For that, she had to have an oral procedure. Counts 9 through 12 are related to the Houston incident, and we'll talk about these. Let's give you a little bit of background to help you remember the facts related to the Houston incident. You'll recall that Christy testified that she was trying or working on the defendant's computer in an attempt to fix it. At this time, she realized that the defendant is meeting with other females that she has not agreed to. People that she did not agree to. You'll recall that there was a time during their relationship where if they spoke about it and she agreed to the relationship, that the defendant would potentially be able to meet up with somebody else. Well, she found out about people that they had not agreed to, and this upset her. You'll recall that she visited a friend in Houston. While she was in Houston, she learns that her favorite snake has died. Erin McInday, the mother, gave us the name of Queen Bee as the snake. How does she learn about this death? Well, she learns about it in the most vague and blasé way you could on the internet. Instagram. There's no phone call to her, there's no personal phone call to her, hey, your snake's dead. I'm sorry. I know the snake was pregnant. Those snakes didn't make it either. There's no phone call like that. There's no personal contact. But she finds out about it on the internet.
I'm going to object that misstates facts.
Okay, so ladies and gentlemen, ultimately you need to rely on your recollection of the testimony. It's not what the attorneys say, it's what you recall that the testimony was. I'm going to allow the argument, but obviously you have to rely on your recollection. Go ahead.
Thank you, Your Honor. Obviously, though, Christy's upset by the loss of the snake. And so when she gets home, even prior to getting home, she's telling the defendant, stay in San Diego. Stay in San Diego. She was cold towards him when she arrived back at her residence. So with that background, let's talk about what happens after. Count 9 is sexual assault. Sexual assault is the intentional sexual penetration against the will of another. Okay? So anything that is inserted, in this particular case, the vagina or anus, would be a sexual assault, so long as it was against her will. The penetration, the definition is, however slight. There was some good discussion on this, about her understanding of what penetration was, and then now you know the legal definition of what it is. However slight, just past the big lips or the labia majora. That is all that's required. If anything goes past that against her will, that is a sexual assault. Now it has to be against her will. That means that either the defendant knew or should have known it was against her will, or that she was incapable of resisting. The crucial question is not whether or not force is actually used to commit this sexual assault, but is more focused on whether it is done against the will of Ms. Christine Mac. That's the crucial question. Not the amount of force used, but was it against her will? Now, the amount of force being used might assist you in determining whether it was against her will, but the crux of the question is, was it against her will, not the amount of force? Submission does not equate to consent. Just because someone gives up that does not mean it's consensual. And the victim is not required to do more than is necessary under, or more than the circumstances would allow. Let me give you one example of that, for example. So, let's say you're out in the desert, going for a run, and someone comes up to you and begins to make sexual advances towards you. You're not required to scream if there's nobody around. Even if there are people around, maybe he's got a weapon, you're still not required to scream. It's dependent upon the circumstances, and therefore you must decide what would have been necessary, if anything at all. Sometimes, and in most cases I would submit to you, no is enough. No. No. That should be enough. Lastly, each sexual penetration is a separate charge so long as there's a break in the action or it's a different insertion into a separate body part. So for example, if a male is inserting his penis into a female's vagina against her will, and then flips her over and inserts his penis into her anus, those are two sexual assaults. Vice versa, if he inserts his penis into her vagina and for whatever reason comes out for a minute, slips out, whatever, and he goes back in, that would potentially be one. But if there's a break in the action or another item is inserted into another area, those are separate sexual assaults. Count 9 is digital penetration. She was lying down watching a movie. Christie was cold towards the defendant that night. The defendant continued to attempt to initiate the sexual contact. There was some cuddling, there was rubbing on the leg, there was some caressing of the butt and breast, and she rebuffed all attempts. No means no. She turned onto her side, and she said that she was struggling then to make sure that she tried to keep her clothing on. The defendant at this time licked his hand. At this time he put his hand on her vagina, thereby attempting to lubricate her, and this was done past her big lips. That is a penetration, and therefore the state has proven beyond a reasonable doubt that this count has been proven, that the defendant committed digital penetration, sexual assault against Ms. Christine Mac. You'll also recall that Ms. Mac testified that she moved his hand away. That is against her will. She did enough to inform the defendant, this ain't happening. The defendant did not stop. Count 10 is the sexual assault for sexual intercourse. There was a discussion that after, or testimony, that after he had licked her, or licked his hand and then wiped her vagina, that he then attempted to dry hump her. He mounted her, and she was penetrated. Ejaculation is not necessary, but Ms. McIntyre testified that the penis went past the big lips. She continually told the defendant no. Count 11, attempt sexual assault. And this was for anal intercourse. When the defendant realized that the vagina was not going to be accessible, he flips her over. And it's at this time that the defendant attempts to insert his penis into her anus. He was unsuccessful. Again, Christie is continually telling him, stop. Count 12, sexual assault for sexual intercourse. He then, realizing that the anal intercourse is not going to happen, he flips her back over. She continues to tell him no. No, no, no. Eventually, she gave up. You saw the size of the defendant in the many photos presented. You saw how large he is. A trained professional fighter. You saw the size of Ms. McInday. At some point, she gave up. That is not consent. And at this point, the defendant is able to insert his penis into her vagina. She's screaming no. Asks him to stop multiple times. This is against her will, and that constitutes a sexual assault. Afterwards, this is an important part in determining how consensual, if at all, it was. After this incident, she goes to the shower. And what's the defendant's response? As she's crying in the shower? What are you crying about? What are you crying about? We've talked about 4 charged incidents. Elaine Green came in here and testified to you regarding the cycle of violence. It starts with a grooming period, and at that point you might reach some sort of high, or things seem lovely and dandy. Tensions continue to build until there's an eruption or a violence outbreak. And at this point, she termed this as potentially one of the lows in the relationship. But after that, there's the makeup period. She described it as hearts and flowers. She even said that sometimes this is the best part of the relationship for the victim. And then the cycle repeats. Highs, tension, lows, hearts and flowers. This was the cycle she found herself in for 15 months. She told you that victims do not always immediately report. And oftentimes if they do report, they reach out to friends before police. She said oftentimes when police actually are involved in a domestic relationship, it's due to the fact that neighbors or the public see something and they call the police. She also testified about this idea that abusers oftentimes attempt to isolate the victims. And why is that? Well, because they want to keep them quiet. This can be done in a variety of ways. They may take their phones. They may not allow their family members to contact each other. And there's sometimes even threats. And that will then lead us to counts 2 and 5, the coercion charges. Coercion is willful and lawful or felonious use of violence or a threat of violence upon another to either make them do something they don't want to do or to have them not do something that they want to do. So this is basically where you're forcing someone to do something they don't want to do. And it's done with force or violence, or a threat of force or violence. Christie testified that the defendant almost always took her phone after the incident. These were his attempts to isolate her from her mother and from her family. Clearly, he did not want her contacting the police. You'll recall, I'll move on. He took her phone almost always, and this occurred almost every time. The state is charged 2. Ms. McInday may not have been exactly specific on exactly which of these incidents these things happened, and therefore, but she said it happened multiple times, and so the state is charged 2. Those are found in counts 2 and count 5. The state has proven this beyond reasonable doubt. Dissuading a witness, counts 3 and 6. Dissuading as a witness is the willful, unlawful, and felonious intimidation or threat to prevent, dissuade, or hinder or delay a person from reporting a crime. Okay? So this would be someone making threats like, hey, I've got Navy SEAL friends and Hell's Angel friends. Don't tell anybody. That's what this would be. That's exactly what the defendant did. He even tweeted. There's an exhibit that's been admitted where he's tweeting about his Navy SEAL friends. Not only that, but it was very interesting. She recalled an incident where the defendant at least pretended, if not truly, but at least pretended to be on a phone call with a Navy SEAL. And he was giving that Navy SEAL her personal information. She thought that was real. And it worked because she didn't report. Now there could be other reasons she didn't report, as Elaine Green testified to, but she didn't report. And that was at least in part due to his threats made to her to hinder or delay the report. She never called the police. And even on August 8th of 2014, when she called the police, what did she do after? While the defendant was still struggling with Cory Thomas, she deletes the calls because she knew she was in trouble. The state charged 2 counts. Again, Ms. McInday testified that this happened multiple times, these threats of force or violence, to hinder or delay her contacting the police. The state has proven beyond a reasonable doubt that these 2 counts have occurred. We're now to August 8th. Let's give you a little bit of background here again. In May of 2014, or about that time, Ms. McInday and the defendant break up. Defendant returns to San Diego. Ms. McInday stays in Las Vegas, and it's at this point that she meets Cory Thomas. Cory Thomas testified that in June of 2014, they met up and they soon began a dating relationship. Cory learned about the defendant, and he knew that the weekend before August 8th of 2014, that the defendant had been back in her life, here in Las Vegas. You might recall that then on August 4th, that Monday, Cory Thomas, who in his mind believed they were still in a dating relationship, attempted to reach out to Christy, to talk about it, to figure out what they want, where the relationship should go or where it should be. Admitted into evidence is a text message from Ms. McInday to Mr. Cory Thomas saying, "I fall into bad habits." They discuss the relationship on Monday. And that brings us to Thursday, August 7th of 2014. Ms. McInday is preparing for a tattoo convention. She doesn't have anything ready, and so Mr. Thomas says, "Let me help you. Let's go shopping. Let's figure this out." They go shopping. He picks up a couple salads. The plan is that they will meet back at her residence, and at that time, they watch some movies, but in the morning, they would be prepared to go set up for the tattoo convention. What crimes occurred on August 8th? The remaining counts 13 through 34, all relate to August 8th, and I will refer to it as the August 8th incident. I'm going to try to do these as chronologically as best as I can, starting with 13, the burglary with use of a deadly weapon. Burglary with use of a deadly weapon. This is the willful entering, so it's an entry into a home with the intent to commit a battery, kidnapping, coercion, or sexual assault. So at the time that the defendant enters the home, what is his intent? That is the question. And we've also alleged that he did this with a deadly weapon. You'll recall that Cory Thomas testified. He parked out front. Ms. McInday doesn't believe the defendant will be present until later that evening, on the 8th. So about 24 hours from when he actually appeared. Maybe not quite 24. But that's when she thinks he's coming. The defendant comes, he sees the car outside. He sees the car outside, a car that he does not recognize. You may recall Cory Thomas's prior testimony, how they went to San Diego and to San Francisco together. And that at those times, they were often photographed together. The defendant sees the car outside at around 2 o'clock in the morning. He's not happy. Any consent to enter the home is not a defense. The fact that he may or may not have had a key is irrelevant, because it's your intent upon the entry, not whether you're allowed. Many of you might give a key to your parents or your siblings who may live in this town. That does not give them an unfettered right to enter your home at any time. It does not give them the right, particularly to enter your home and beat you. It's the intent with which you enter. That is the focal point. We've talked about most of this. I should also note that earlier that night that Ms. Mac had sent the defendant a provocative photo and some other texts that would imply that they are at least have sexual interest with each other still. And when he finds that car parked out front, he's not happy. The testimony was that bedroom door flew open. Cory Thomas testified that the defendant mouthed WTF and not those words. I will spare your ears, as I'm sure you've heard plenty of things you wish you could forget in this trial. WTF. And he immediately jumps on and attacks Cory Thomas. What is his intent when he entered? He's mad. And he beats Cory Thomas. His intent was to beat Cory Thomas. That was one of his intents. If you find that he intended to commit coercion or sexual assault, that would also qualify as a burglary. The only question left then is whether or not this burglary was done with use of a deadly weapon, or while in possession of a deadly weapon. A deadly weapon is any instrument that is capable of causing substantial bodily harm. I guess not capable. It's used in a way that could cause substantial bodily harm, or it's specifically designed to cause substantial bodily harm. For example, guns. Those are things that are designed with the purpose of injuring, maiming, or causing substantial bodily harm. Bats would be deadly weapons under the second part of it. The way in which it's used can cause substantial bodily harm or death. So what deadly weapons are we talking about here? The deadly weapon for burglary only has to be in his possession, only for the burglary count. If he, at any point during the burglary, while he's inside that residence, if he picks up or possesses a deadly weapon, that is burglary with use of a deadly weapon. Maybe properly more titled as burglary while in possession of a deadly weapon. We know he had a knife. The burglary has already been committed. The instructions tell you that at any point during that burglary he uses it or picks up a knife or any other deadly weapon, it's burglary while in possession of a deadly weapon or burglary with use of a deadly weapon. He begins cutting up the wigs. We saw evidence of that. We saw her hair all over the place in the room. We saw it cut on her head. We know he had a deadly weapon. And we also know that he went back downstairs to grab another knife. Count 27. Again, I'm trying to go in chronological order at this point. The defendant enters with the intent to batter and beat up the man who is in bed with Christine Mac and Dave. Count 27 is battery resulting in substantial bodily harm. These are for the punches to Cory Thomas's face. We've discussed what battery resulting in substantial bodily harm is. He immediately pounces on Cory Thomas, strikes him numerous times to the face. He said it was 5 or 6 punches before he was even able to get his guard up. About 20 total. He continues to wail on his face while he's in bed. This results in a broken nose, which he says he still suffers with. When he wakes up in the morning, he's got to clear it out, and it affects his breathing. It affects an organ, a member of the body that has impaired it. That's substantial bodily harm. Count 28, battery resulting in substantial bodily harm. And this is for the bites to Cory's face. As the defendant is wailing on him in bed, Cory Thomas reaches up and pulls the defendant down towards him so there's no more distance to throw punches. And it's at this point that he bites Cory Thomas on the face. On the face. You'll see in this photo here after he's cleaned up. You can see the bite mark there on his lower right cheek area. He still has a scar. That would be substantial bodily harm. As he pulled him down, there's also bite marks on his arm, which causes scarring. Both of those are permanent disfigurement, and that would constitute substantial bodily harm. We've charged for face or arm. If you believe that he bit the face or the arm, the defendant is guilty of battery, resulting in substantial bodily harm. Count 29. This is for the shoulder, the dislocated shoulder of Cory. Cory testified that at the conclusion of the brawl, his shoulder was dislocated. You might recall Mr. Toronto's showing you what a seatbelt hole was. I didn't really follow it that closely. I'm not much of a wrestler. But you saw kind of how Mr. Sua's arms were kind of all whacked. Maybe that's what happened. I don't know. It doesn't matter. What's important is the fact of the matter is that his shoulder was dislocated. He's testified that for a year he had to rehab that. He could not do certain things or participate in certain activities. This is a prolonged physical pain, something beyond the immediate pain associated with that. This is substantial bodily harm. Count 30 is battery by strangulation. Counts 30, 31, and 32 are for 3 different chokeholds that the defendant had on the defendant. Strangulation, this is unlawful contact that impedes the breathing, creating a risk of death or substantial bodily harm. It does not require the person to pass out. It does not require the person to see stars. It does not require him to lose consciousness. The first strangulation occurs after they're fighting on the bed. Mr. Thomas is able to push Mr. Copenhaver over to the right side, and Cory Thomas attempts to roll to this side of the bed. And it's at this point that the defendant jumps onto the back of Mr. Thomas. Mr. Thomas pushes off from this area, whether it be the bed or this step here, but he pushes him off into the wall back here. What was the testimony of Cory Thomas? He testified that he had a difficult time breathing, that his breathing was impeded at that time when the defendant had him around the neck. This is not me attempting to choke somebody out. This is a trained professional. If he impeded the breathing in a way that would cause substantial bodily harm or death, he's guilty of that count. The defendant only let go once he was smashed into the drywall. Cory Thomas testified after that, when he's caught between this entryway, when it's difficult for him to move, the defendant hit, in Cory's own words, says, he got a good one on me. He had a difficult time getting around in that small area right here. It was difficult for him to move her, to get around in a better defensive spot. He thought he would die in Christine Mac's bathroom. In this one, he testified that he saw stars. He began to go unconscious. His last effort was to stick his hand up between the hold and his neck in an attempt to fight off the lack of oxygen. This saved him from going unconscious. At some point, the defendant, or Mr. Thomas, is able to leave that area, and he goes back more out towards the front. He testified that he was on kind of forward, hands and knees. And at that point, the defendant gets him into another chokehold. This is count 32. Again, Cory Thomas testified that this chokehold, this third chokehold, was still impeding his breathing. He was still having difficulty breathing. You might recall that even if it's a seatbelt hold, if you believe it's some seatbelt hold, although Cory Thomas never testified to that, in fact he said, I don't know what a seatbelt hold is. But if you believe that somehow this is a seatbelt hold, you might recall the demonstration with Mr. Sua again and Mr. Toronto. As Mr. Toronto was squeezing Mr. Sua, you might recall that at the end of that, Mr. Sua coughed. presumably for breath. If you believe that it was impeding his breathing, he's guilty of battery by strangulation. He testified that at each choke, he had a difficult time breathing. He's guilty of all 3 counts of battery by strangulation. Count 33 is the attempt murder charge on Mr. Cory Thomas. Attempt murder is the performance of an act which tends but fails to kill a human being when done with express malice. Okay? So this intent must be had at the time that you have this, when you're committing the act to kill. The fact that a person does not finish someone off, that is not a defense to attempt murder. The fact that it was the defendant that let Mr. Thomas go is not a defense to murder. If during that time he intended to kill Mr. Thomas, then he is guilty of attempt murder. 3 different chokeholds. One of them, a good one, where Mr. Thomas testified he thought he was going to die. He's able to fight off the first one only by slamming the defendant into a wall. The second one, he's able to get his hand through the choke. And on the third one, he's on all 4s. Cory is the one that begins the conversation. Cory's scared. He thought he was going to die. And he starts a conversation. And he says, "Are you going to kill me, or are you going to let me get out?" And it's after that conversation where the defendant chooses to let Cory go. He intended to kill Mr. Cory Thomas. And that constitutes attempt murder. Count 34 is the dissuading a witness. We've talked about this one already as it would relate to counts 3 and 6. So I'll skip some of the legal language on it. But the defendant only permits Mr. Thomas to leave the residence after he tells him, "I've got Hell's Angels and Navy SEALs buddies. Don't go reporting this." It's only at that time they give each other a nod, and Mr. Thomas is able to walk out. This is the same threat used against Ms. McInday. And he did not call Cory, did not call the police for a while. Shows that clearly it had some impact on Mr. Thomas. Let's talk about Ms. McInday. This will be back to count 14. This is first-degree kidnapping with use of a deadly weapon resulting in substantial bodily harm. We've talked about kidnapping. It's the willful seizure or confinement of an individual with the intent to commit either substantial bodily harm, murder, or sexual assault. So here we have the defendant willfully seizing and confining her for 2 hours. This is after Cory left. The first thing she remembers once Cory left is the defendant charging her. From there, she remembers waking up in the shower. Their past history is important in understanding her psyche at this point. What's she thinking? What's going through her mind? Does she feel like she's free to leave? Defendant for 2 hours is with her. And the only time she's able to flee is when he goes to get a knife. Defendant is pummeling her during the 2 hours. You've seen the injuries on many photos, and you'll see some again. Defendant had a knife nearby. She was not free to go. So the thing for us to discuss then is, what was his intent? Is his intent to commit substantial bodily harm? I submit to you, yes. He had just finished beating Cory Thomas for being in bed with Ms. McInday. Why not exercise the same punishment against Ms. McInday? What is his intent? You've seen the photos. Multiple facial injuries, bruising, lacerated livers. His intent is to commit substantial bodily harm. His intent is also to commit sexual assault and even kill Ms. Christine McInday. You'll recall that he licked his hand in preparation for a sexual assault. These go towards his intent. He cuts her on the head, pokes her on the hand and in the ear. He goes downstairs to eventually get a knife. These all go to what his intent is, and that is to cause substantial bodily harm or kill Ms. McInday or commit sexual assault. The state has proven beyond a reasonable doubt that he committed first-degree kidnapping. So the questions then remain, was a deadly weapon used, and did substantial bodily harm result? Well, she's cut on the head. You've seen the photo. There it is. She's poked in the ear, in the hand, and now you must determine if substantial bodily harm resulted. We've talked about the injuries. There's this huge bruise on her leg, injuries all over here, a blowout fracture to the orbital, multiple nasal fractures, the vomer fracture. Substantial bodily harm occurred to Ms. McInday. The defendant's guilty of first-degree kidnapping with use of a deadly weapon, resulting in substantial bodily harm. Count 15 is coercion. This one's alleged as sexually motivated. Coercion is using violence or threat of violence to compel another to do something they don't want to do. And to be sexually motivated, it has to be for the purpose, the state must prove beyond a reasonable doubt, that it's for the purpose of some sort of sexual gratification. Well, he forces her to disrobe and enter the shower. The defendant just charged at her. She wakes up or regains consciousness or remembers next that she's in the shower naked. And it's not long thereafter that he sexually assaults her. What is his intent? His intent is to get her in a position where he can fulfill his sexual desires. Count 16 through 20. All these ones relate to battery resulting in substantial bodily harm constituting domestic violence. We've talked about this one already, so I will spare you reading through the legal definitions. Count 16 is for the blowout fracture. I believe it was of the left eye, if I recall correctly. That is count 16. A blowout fracture to the eye. That's substantial bodily harm. It impairs a bodily organ. Count 17 is the broken nasal bones. These ones required surgery. Again, broken bones, substantial bodily harm. Count 18 is for the mouth or for the teeth. You might recall this photo. Dr. Walker testified to some sort of avulsion, which is the loss of a tooth. This required several surgeries, several operations. This is substantial bodily harm, where she actually lost a tooth, along with injury to other teeth. Count 19 is for the leg. Ms. McInday's testimony. She could not walk for several weeks, and even when she was walking, she was limping. Prolonged physical pain, something beyond the initial impact of the injury. 2 weeks. 2 weeks she's not able to walk. Count 20 is for the ribs or the abdomen. There's a lacerated liver in the abdominal area. Dr. Walker testified that this would be something you would see from a car accident. It would require that much force. Substantial bodily harm, the impairment of a bodily organ. The defendant is guilty of counts 16 through 20 for battery resulting in substantial bodily harm constituting domestic violence. Counts 21 through 23, these are battery with use of a deadly weapon constituting domestic violence. We've talked about this, but essentially the state must prove that the defendant committed a willful and unlawful act against Ms. McInday with the use of a deadly weapon. What deadly weapon? Count 21 is for the cutting or poking of the hand. Her testimony was that he poked her or cut her on her hand with the knife. Count 22 is for poking in the ear. Poking in the ear. Many of us don't even like wet willies. And yet he's using a knife. Poking it inside her ear. Count 23 is for the head. That laceration on the head. These were all done with a knife. These were all done by a domestic partner of hers. And these all constitute batteries. He's guilty of counts 21 through 23, battery with use of a deadly weapon, constituting domestic violence. Battery with the intent to commit sexual assault. We haven't spoken about this one, so let me talk to you a little bit about legally what we must prove. Battery is any willful or unlawful use of force against another. And for this count, the state must also prove that these batteries were for the purpose or the intent of committing sexual assault. The defendant is slapping, punching, hitting, kicking Ms. McInday as he's going through her phone. And what is it that causes him to continually hit, punch, slap, or kick her? Well, he gets upset every time there's someone in her phone that he doesn't approve of. If they're following him on Twitter, if it's a contact, whatever it may be, this is what's causing him to be upset. And what is that purpose? Well, from the Houston incident, he's trying to get her to submit, to not fight. What is his purpose? What is his intent? His intent is to beat her down where she cannot, or she could potentially be physically incapable of resisting. In the defendant's own words to Ms. McInday, I'm going to take my pussy back. Those were his words to her. Count 25 is the sexual assault with use of a deadly weapon resulting in substantial bodily harm. This is penetration of the vagina, however slight, against her will. You'll recall that he licked his hand. He places that past the big lips on her vagina, and it's at this point the defendant is again saying he's taken her back. Was a deadly weapon used? Ms. McInday testified that the knife was not in his hand at this specific time, but it was nearby. For the use of a deadly weapon to occur, the deadly weapon simply must be displayed in a manner that would cause someone fear. For example, let's talk about some of the movies we might have seen. When a bank robbery occurs, someone goes in, talks to the teller, says, "Hey, this is a stick-up, give me all your money." The teller might be like, "Psh, you're 12 years old, man!" Right? Then he opens up his jacket, shows the gun. That's robbery with a deadly weapon. Because at that point, you're forcing or causing somebody to comply with your demands. This is with use of a deadly weapon. The knife was nearby, and he had already used it to injure her on her hand, on her ears, on her head, and it resulted in substantial bodily harm. There are numerous broken bones, there's a lacerated liver, and you'll recall Mr. Geraldo's testimony that when he saw her pop up in front of his door, he thought it was a bloody monster. Substantial bodily harm occurred. Now, there's one thing I need to clarify with you, and that is that a sexual assault and kidnapping need to be further differentiated. It cannot be a kidnap and a sexual assault if the kidnap and sexual assault are the same act. That doesn't really apply here, but let me just clarify it just to be sure. Let me give you an example. There's a person, a defendant, a suspect, enters a bedroom through a window. And at that time, he holds his victim down and he rapes her. Technically, that would be a confinement and a seizure, as we've learned. That could be a kidnapping. However, because there's not some sort of independent purpose or any sort of movement towards her, this would constitute only one of the two. You can't be convicted for both when it's one act, essentially, is what we're trying to avoid. Okay? So the confinement or seizure is for the purpose of effectuating the sexual assault. The purpose of it is to hold her down to commit the sexual assault. This is not necessarily a kidnap. If there's an independent purpose, however, then it would be. And let me give you an example of that. This same person enters through a bedroom window. And at this time, he locks the door and he locks the window. And at that time, he commits the sexual assault. That one would be a kidnap and also a sexual assault. because now he has confined her with a separate purpose, and that is to prevent discovery of the crime itself, to prevent her from leaving, for her to comply with his demands. So if there's an independent purpose, then you can convict of both. This would be a kidnapping in that example. In this particular case, there's an independent purpose to the kidnap, because this kidnap isn't just for the few moments where he sexually assaults her. This is for a 2-hour period where he keeps her confined in that bedroom. He stays in that room with her with a knife before and after the sexual assault. He did not want her fleeing to contact the police, and he did not want her injuries becoming public. He took her phone everywhere that he went that night, or that early morning, I guess. You'll recall that her testimony was that even when he went downstairs back to the kitchen for a knife, he took her cell phone with him. He kept her in that room so he could kill her. And that's the defendant's own words. Now, I've got to kill you. It had an independent purpose beyond the sexual assault. You can convict of both, and the state has proven beyond a reasonable doubt that you can convict of both. He's committed both of those crimes. She only flees once he leaves the room. Attempt murder with use of a deadly weapon. This is again the performance of an act designed to kill, but failing to do so. The defendant severely beats her, uses a knife, and he tells us what his intent is. He says, now I've got to kill you. Christy, as the defendant is downstairs in the kitchen, can hear knives or metal clangings going on in the kitchen, and it's at this point that she flees. The fact that she flees and the defendant is unable to complete the crime does not negate the attempt murder charge. If at some point when he is beating her, hitting her, attacking her, if there is an intent to kill, he is guilty of this crime. 2 hours of this. He tells us what his intent is. The fact that Christy flees, I want to talk to you very briefly, and I will be done soon, about the defendant's own flight. There's an instruction in there that says that flight itself does not establish guilt, but it's something you can consider in determining a consciousness of guilt. Okay? Why do people run? That's more or less what it's asking. We know that the defendant, after this, fled to Simi Valley. He checked into a hotel where it was registered to another person in another name. We know that the marshals knocked and announced their presence at the door. We know that they had to use a ram to get inside the door. And we know that he wasn't compliant initially, and a taser was used. All of this shows a consciousness of guilt. We also know that he contacted Aaron McInday. He might have been feeling a little bit of remorse for what had happened, but he contacts Ms. McInday to let her know what's going on. He doesn't stay. He doesn't stick around to explain what happened. He flees. This is a consciousness of guilt. When he flees, it shows a consciousness of his guilt. When Christy leaves, she's fleeing for her life. Lynn Green testified that many victims of domestic violence do not report. And the most common way it's reported is when a neighbor calls the police. Dasha, Alberto, and Arthur saved her life because they got involved. They called the police. They were scared. You heard their testimony. They were scared. Can you imagine what Christy must have been feeling at that time? She was scared. They were scared. But they did the right thing and they called the police. It's at that time that Ms. McInday is able to come in and meet with the district attorney's office. And it's at that time, just as Ms. Eileen Green told us, where she disclosed more acts of violence. Dasha Alberto and Arthur saved her life. Not just on this day, not just on this day, but it's because of that Christy had the strength to break the cycle of violence that she had been living with for 15 months. Because they got involved. The defendant attacked and pummeled Cory Thomas. He is guilty of counts 27 through 34 for those acts. He attacked, beat, coerced, and sexually assaulted Miss McInday over a 15-month period. And he's guilty of those crimes, counts 1 through 26. The state has proven him beyond a reasonable doubt. And at this time, I ask for your consideration in finding the defendant guilty of all counts. Thank you, Your Honor.
Thank you. All right, folks, so what we're going to do, I know it's kind of late already, is we're going to take a lunch break. We have ordered lunch for you, and because we're able to stay in and eat, we're only going to take about a half hour, and then we'll have the defense closing argument and the state's rebuttal argument. Now, the case is still not submitted to you yet because the arguments haven't finished, so even though you're going to be going in the back to eat lunch, you have to continue to abide by the admonition